Proposition 34 asks voters to end California's decades-old death penalty law, while Prop 36 aims to modify the state's 1994 three strikes law. Other voter-approved measures, like Jessica's law that restricts where sex offenders can live, have been in and out of courts for years. Here to talk about the effectiveness of popular voter initiatives and possible ways to improve the process is Glenn Smith, constitutional law professor at California Western School of Law. Glenn, thanks for joining us today.
You're welcome.
What do attempts to change these previously approved voter initiatives like Prop 34 and 36 say about our process of initiatives on the ballot?
I think there's two different messages in those two propositions. The fact that the citizens can put on the ballot an unpopular and a politically dangerous attempt to reform the death penalty tells us that's one of the good things about the initiative process. It can get beyond some of the inertia in Sacramento. What the other three strikes proposition tells us is when we're passing a complicated provision that relates to the criminal justice system and may have all kinds of fiscal and other unintended consequences, the initiative process can fail to inform voters and others about the full extent of it. And people can vote for something they think they're voting for, and they don't really get what they think they're voting for, and all these other problems result from it. So we have the good and the bad part of the initiative process on display.
And one of the problems is, like Jessica's law, these initiatives can end up for years in courts. What is on this ballot initiative that you see as red flags as to heading to court?
Well, I think I would say the political campaign proposition. Whenever you have political campaign regulation, it generates litigation. I was intrigued to see that the genetically modified food proposition, in the very description by the legislative analyst, that neutral description that tells voters what the proposition does.
Prop 37, the labeling of genetically modified foods.
There's a sentence in there that says, given the way it's written, there'll probably be a court dispute about a certain provision. And that piqued my interest. I'm a law professor, and we're interested in the way courts interpret these things. And I thought, wouldn't it be nice to have a process where that at least could be addressed before we vote on it?
And they're warning you almost, it seems like. What are the two types of initiatives on the ballot?
Well, there are, as they're called, these citizen initiatives. Of course, they can come from large interest groups and politicians. But those are ones that are generated and written from the outside of the legislature, and people sign petitions. The legislature itself, though, can put propositions or initiatives on the ballot that it votes on and then sends to the people, and that's the basic difference.
What's wrong with having citizens making legislative decisions, coming up with these laws? Isn't it part of the democratic process?
Well, it is, and if the process works well and gives the voters who are acting as legislators twice a year the information they need and the perspectives, and has all of the elements of deliberation that the legislative process has, that would be great. That's the downside. I'm not proposing that we abolish the initiative process. It's not going to happen. But what I think could be done is the process could be made a lot better. It could provide better information. And some of the standard things
how could it be made better?
I'm sorry. When a legislator introduces a bill, he or she has to introduce a statement and say what it's going to do and what it doesn't do and what its goals are. And it would be great if initiative sponsors had to do it in that sort of specificity. And then, of course, there's a hearing process where supporters and opponents can come in and raise objections and raise questions and bring up issues that can then be addressed. So that's what I think really would happen.
All before it gets on the ballot?
Yes, yes. Mm-hmm. And actually what it would do is mimic a process that we now have used for 50-plus years for administrative regulations, which are law. Before an administrative agency can change the law, they have to tell you what they're proposing to do, hear from people, and then informally and streamlinedly say, here's our response.
What about the legislators themselves? I mean, isn't it their job to come up with laws that help us? And they should do that in Sacramento. How come it's always, let's give it to the voters, let's give it to the voters?
It's an interesting and multifaceted answer to that. But I do think that there are some legitimate examples of what the supporters of the initiative process expected, that for various political reasons, special interest and all that, the legislature wouldn't be hospitable to certain ideas. But I think it's also just become a way for people who don't have the majority in the legislature or who think they have some great new idea to propose it. And I think it's a bit insidious. The legislature doesn't do its job as much because they know that there's going to be things happening in the initiative process that are going to make it harder for them to do their job or let them off the hook. So I think it would be better if the legislature did more of the legislating, and we use the initiative process for, reforms or
ideas, maybe?
huge ideas that come out, from grassroots. That's what it was intended for. That's what it should be. But without the kind of useful process, it doesn't often do that.
All right. Well, we're going to have to end it there. Constitutional law professor Glenn Smith, thank you so much for talking with us.
Oh, my pleasure.